speculate what irregularity the applicant relies on for impugning an administrative decision. Now, that passage, my lady, comes from the Lesotho Public Service Staff Association as the first appellant and the Chief Magistrate, Northern Region, and others. I'll make a copy of the judgment available to my lady. Now, my lady, clearly, the appeal court has set out what the procedure for a review is. Now, if one considers the papers submitted by the applicant simply makes a bold allegation that the DPP did not properly apply her mind. Another bold allegation that the decision was irrational. Now, those are allegations. The jurisprudence demands that those allegations must be substantiated by some factual matrix upon which you can make a decision. In the present instance, there is none. My learned friends take issue with the fact that the erstwhile Director of Public Prosecutions is not deposed to an affidavit. In terms of the citation of the matter and the manner in which the parties have been cited, she's not been called upon to do that. She ought to have been cited as the decision maker. If you're challenging the decision made by a particular administrative functionary, that functionary is entitled to an opportunity to answer. You simply cannot make bold allegations but not cite the party and give that party an opportunity to respond. In the present application,
she should have been cited in her personal capacity.
My lady, if we look at other matters that are presented even in the Constitutional Court, where the Director of Public Prosecutions at the time was required to answer certain allegations, they have been cited. But notwithstanding, the office of the Director of Public Prosecutions is not cited. The Crown is cited. So the incumbent Director of Public Prosecutions deposes to an affidavit protecting the position of the Crown. Now, there's no argument and there's no allegation that the Director of Public Prosecutions acted irregularly. And there cannot be a sustainable allegation that she acted irregularly. My learned friends have selectively drawn on pieces of legislation. But in order to come to a proper decision in respect of whether the decision taken by the Director of Public Prosecutions to indict in the High Court was rational, reasonable, and within her powers. Now, there are various aspects that have to be raised in a review, and my lady would have seen that I've put it into my head. There's a whole host of grounds upon which a decision can be impugned. It must be ultra vires. That's not one of the allegations made by the applicant or the joiner in, the second respondent. And clearly, on their own submissions, she's empowered by the supreme legislation, the Constitution of the Kingdom of Lesotho at Section 99. Section 99 of the Constitution is the legislation that creates the office of the Director of Public Prosecutions and sets out the extent of the powers and discretions that she has. issue has been taken with what might colloquially I'll refer to as a collateral authority of the Director General of the DCEO in terms of Section 6 of the Prevention of Corruption and Economic Offences Act. Mention has been made of Section 43 of the same Act. And Section 144(1). Now, my lady, in order to impugn a decision or to set aside a decision taken by the Director of Public Prosecutions, the court is constrained to consider the provisions of each and every one of these different provisions. And they all have to be read together because they all deal with the discretionary power vested in the Director of Public Prosecutions. Now, Section 99 of the Constitution, which creates the office of the Director of Public Prosecutions, at Section 99(2), it sets out the Director of Public Prosecutions shall have power in any case in which he considers it desirable to do so. The act is in the masculine gender. I'm just going to continue to read it as it is, my lady. No disrespect. Subsection A reads, to institute and undertake criminal proceedings against any person before any court other than a court-martial in respect of any offense alleged to have been committed by that person. B, gives the Director of Public Prosecutions to take over and continue any such criminal proceedings that have been instituted or undertaken by any other person or authority. There's no need for me to read the rest, but I'm just going to read it for completeness of the record. The Director of Public Prosecutions also has the authority to discontinue at any stage before judgment is delivered any such criminal proceedings instituted or undertaken by himself or any other person or authority. Now, what has the Director of Public Prosecutions done according to the applicant? The matter was seized before the subordinate court. The DCEO was issued with a directive to proceed. But I must point out that the record of the 23rd of September 2023 has not been put up by the applicants as proof that the matter was set down for a hearing or for the trial to commence. That's just to say so. But that notwithstanding, Section 99(2)(b) gives the Director of Public Prosecutions to take over that matter, even though it is being undertaken by another authority, that authority being the DCEO. So she's acted within the powers that are vested in her by the supreme law of the land. So jurisdictionally, in terms of the power and the authority granted to her by the Constitution, she's complied. Now, when we look at the other arguments raised by my learned friends, Section 144(1)(b) of the Criminal Procedure and Evidence Act clothes the Director of Public Prosecutions with the authority to remit matter for summary hearing before this honorable court in specified circumstances. But what is of greater importance is that Section 144, when it is semantically examined and interpreted, says, whenever in the opinion of the Director of Public Prosecutions, any danger or interference with or intimidation of witnesses exists, that's one of the grounds on which a remittal may take place. Section 144(1)(b) says, the Director of Public Prosecutions considers it to be in the interest of safety of the state. That's another one, another ground upon which she may do the remittal. Now, the use of the word "or" in the statute creates the third alternative, the third ground upon which she may consider a remission for trial, a summary trial before the High Court. And that is if it is in the public interest. Now, the current locus classicus in respect of an application of this nature was heard before the appeal court. And that's, I hope I'm saying it correctly, it's Ramoepani. I think I'm saying it correctly.
Yes.
It's a judgment referred to by my learned colleagues, but rather sparingly. It's important that the full extent of that judgment be considered. Well, the counsel for the applicant addressed you on the issue that once a directive is given by the Director of Public Prosecutions to the DCEO to institute a criminal prosecution, she's got to wash her hands of it and leave them to do it. That's not correct. That is not correct, because Section 99 of the Constitution clearly says that she can take over the prosecution from any authority at any time. But what is not mentioned is that additionally, in the same legislation that creates the office of the institution of the DCEO, Section 46(3) of the legislation provides for the parameters in which the DCEO may prosecute. So it's not carte blanche that once that directive is issued, there's no turning back from there. The DPP has no oversight role or cannot take over the matter. As I've mentioned, Section 99 of the Constitution already gives her that authority. But even in the legislation creating the DCEO, where offences in Chapter 4 and 5 are being prosecuted, those prosecutions may only be instituted under the directive of the Director of Public Prosecution. Sorry, I've been referring to Section 46, it's 43. Section 43 of the Prevention of Corruption and Economic Offences Act. Section 43(2) makes it abundantly clear that no prosecution for an offence under Part 4 or 5 shall be instituted except by or with the written consent of the Director of Public Prosecutions. Now, if those matters are to be indicted for summary trial to the High Court, it's common sense and common cause that only the Director of Public Prosecutions has the authority to indict and to sign an indictment. It is not for the office of the Director of Public Prosecutions or for the Crown to defend a position under review. The case has to be made out by the applicant for the review. The applicant has got to convince you that the impugned decision is so unreasonable that no sane person could have made that decision. Now, what could possibly prompt a decision to remit the matter for summary trial to the High Court? If one considers the allegations in the indictment, and I've mentioned them in my heads, the grounds upon which it is justifiable for the matter to be remitted for summary trial to the High Court. The profile of the accused persons, the nature of the offence itself, the general public outcry in respect of government corruption and procurement corruption, and a need for the further development of the jurisprudence, particularly in terms of punishment and the levels of punishment, and how the courts view the corrupt activities of politicians and high-ranking government officials. That's justifiable in itself. Now, in Ramaopane, the appeal court made it quite clear that the exercise of a discretion, by its very nature, indicates that there could be more than one or two alternative decisions. And it is an individual discretion that the functionary is blessed with. He may exercise that discretion in any choice that he chooses to make. The only qualification is that that decision must not have been made capriciously. It must not have exceeded the extent of the power and authority vested in that position that he occupies. Now we talk about prejudice. It's trite in administrative law on a review. A person that is prejudiced has the right to bring before you an impugned decision. What is the nature of the prejudice that's pleaded in the present instance? That the applicant could not afford King's Counsel to represent him because he could have afforded King's Counsel's appearances in the subordinate court, but was unable to afford King's Counsel in the High Court. And lady, those can't be grounds to claim prejudice. My lady raised a very, very pertinent issue with both of my learned colleagues. And they appear not to have addressed it to the extent that I would have been happy to. And it demands a further ventilation. My lady questioned the timing of this review. Why now? Now, when one considers the history of the matter, let's deal with the history on the applicant's submissions. The cause for complaint and the decision they seek to impugn occurs in September 2023. In September 2023, the applicant is represented by King's Counsel. I stand to correction, but I think accused number 2, the joiner in, was represented by present counsel at that stage as well. Now, my lady, if you have a decision that you believe to be capricious, you believe to be prejudicial to you, and you believe that is capable of being impugned, why do you wait exactly 2 years before you bring it? It's opportunistic. Because had the applicant timeously taken the impugned decision on review, if it was the view of the reviewing court that the matter ought to be remitted back to the subordinate court, he may still have the services and counsel of his King's Counsel. He doesn't have the services of his King's Counsel because he didn't act timeously and responsibly. Now, what has happened since September 2003 and September 2005? This matter presented before the High Court on indictment. The accused have been appearing in the High Court for the last 2 years. And in 2 years, no complaint is raised. The indictment has been in place ever since they were remitted to the High Court. Counsel for the accused participated, number one, in the allocation of hearing dates, trial dates, for the matter to be heard. They participated in the pre-trial process and still raised no issues. In that period, and given that conduct, this court has done what it is entitled to do in terms of Section 6 of the High Court rules and the common law. You have mero motu assumed jurisdiction in the absence of any challenge. Now, when one considers the other argument that these charges are justicable in the subordinate courts, and it must be there. No, that's not what the Subordinate Courts Act does. The Subordinate Court Act increases the jurisdictional limits of the subordinate court, but that does not in any way fetter the overarching jurisdiction of the High Court. It's common sense that the High Court may hear any matter that is placed before it, except matters of a military nature that go to a court-martial. One issue that my learned friends have not addressed you on is the tacit consent to the jurisdiction of this court. When you participate in the processes for 2 years, you have effectively and tacitly accepted the jurisdiction, the indictment, and the remission of the matter to this court. Now, when you feel the pinch of the shoe, when it's time to plead and for the trial to start, then the indictment becomes an issue. Then the summary trial before the High Court becomes an issue. But it never was an issue for the last 2 years when the matter presented here. The appeal court, in the matter referred to by my learned friend, have gone back and checked it. When they say you must raise your plea of jurisdiction in the court seized with the trial, what is envisaged is a plea to jurisdiction in terms of Section 162. Section 162 of the Criminal Procedure Act sets out very clearly that one of the pleas that an accused person may raise is a plea to the jurisdiction, a challenge to the jurisdiction of the court that is seized with the matter. They have not been called to plead. The correct time to have raised the jurisdictional issue would have been when they were called to plead, because Section 162 clothes the accused with that right to challenge the jurisdiction. But even then, it is a matter that you would have dealt with, not on a review of the decision taken. Having said all of that, my lady, I refer, my lady, to various passages in the Ramaopana matter, because that must now be considered to be the ruling jurisprudence in respect of the exercise of the discretion by the Office of the Director of Public Prosecutions. The public interest has extensively dealt with in this judgment. The right of the citizenry to know what is going on, and given the nature profile of the crime and the accused, is sufficient grounds upon which to have a matter remitted for summary trial to the High Court. This matter falls on all fours with Ramaopana. On all fours, it's the same thing. Exactly the same arguments were raised in exactly the same set of circumstances. A matter seized before the magistrate's court, the DPP indicts, and there's a summary trial in the High Court. Challenge taken in the magistrate's court, thereafter taken on review, dismissed. What solid new jurisprudence does the applicant and the second respondent bring before you to say that position has changed? In the absence of any substantive allegation with proof that the decision was capriciously made, that the decision is wrong, and that that decision is not supported by an empowering statutory provision, no case has been made out for the setting aside of the indictment to the High Court. In those circumstances, and given that the accused have had 2 years within which to bring a challenge to the indictment, and they only bring it now when the matter was already supposed to have been heard in trial, it's opportunistic, and an appropriate cost order ought to be issued to dissuade accused persons from bringing these frivolous applications. Now, I say frivolous because in the absence of substantive allegations with an underlying factual matrix, that's frivolous. It's an abuse of the process. and a stern message must be sent out to accused persons that you simply cannot, as a way out, challenge the statutory discretion that the DPP's office has, unless you DM me on anything in particular.